Thank you, everyone. Please be seated. Welcome this evening to this special session of the Iowa Supreme Court held on the campus of Buena Vista University in Storm Lake. And we are all privileged and honored to be with you this evening. Thank you very much for spending part of your evening with us. We have two cases that you will now hear. The first is City of Sioux City versus Michael Jacobsma, and the second case is State of Iowa versus Donald King. We'll hear the cases in that order. We'll take no break between the cases, and we'll enjoy talking with you at a reception following. We'll now hear the arguments in the first case. Mr. Jacobsma, you may proceed.
May it please the court.
Counsel.
Counsel for Sioux City. My name is Michael Jacobsma, and I am the defendant in this matter. I'm here before this honorable court representing myself. By doing so, perhaps I'll resemble that old proverb that says, "He who acts as his own lawyer has a fool for a client." We'll see. But even if I do, I believe it was Justice Harry Blackmun of the U.S. Supreme Court who said that every person has a constitutional right to make a fool of himself. In all seriousness, though, I am here challenging the constitutionality of Sioux City's speed camera ordinance. Now, this is how this ordinance was crafted to work. Sioux City has various cameras positioned on various highways, and these cameras photograph and video a vehicle that is speeding. The city obtains the license plate information from the photo, determines who the registered owner of the vehicle is, and then prepares and issues a citation and mails that citation along with a letter to the registered owner. Not personal service, just by ordinary mail to the owner, and basically says, "Congratulations, Mr. Registered Owner of the vehicle. Your vehicle was photographed speeding, and you now owe us money." Now, this ordinance doesn't require the city to prove that the owner of the vehicle was the actual driver at the time. It doesn't have to prove that the owner authorized the speeding, nor does the city have to prove that the owner of the vehicle in any way caused the speeding to occur.
Well, I'm not sure of that. The ordinance allows a presumption that the owner of the vehicle was the driver, but it's certainly rebuttable, and you had an opportunity to rebut the presumption, did you not?
Well, Your Honor, what I would argue is that the language of the ordinance really doesn't provide a rebuttable presumption. The only rebuttable presumption that it authorizes is that one very narrow circumstance where the registered owner can rebut the presumption if, during the time in question that the speeding violation occurred, the owner filed a stolen vehicle report with the police.
Or nominate a person by affidavit saying who actually was driving the car. And is it rational for law enforcement to believe that the owner of a car who consented to its use knows who was the driver?
Well, Your Honor, first of all, with respect to the nominated party issue, the language of the ordinance is extremely vague on that. It makes a reference to a nominated party, but doesn't describe or define what who a nominated party is or what a nominated party is.
Yeah, actually, I agree with that. But did you make any effort to nominate a party?
No, I did not, Your Honor. I did not.
So, I mean, the record is that I understand stolen vehicles, and let's net that out for now. But you had an opportunity to nominate someone pursuant to a vague ordinance. But you made no record before the magistrate with respect to that issue. I mean, am I correct?
That is correct, Your Honor. There was
Okay.
no particular nominated party.
So at the end of the day, the record is that I think you stipulated the fact you're owner of the vehicle, and there was no evidence to the contrary before the magistrate. Is that problematic?
Well, the ordinance, Your Honor, provides that as we said, this nominated party. And no, I did not present any evidence of a nominated party. But the problem, I believe, with the ordinance also is that, well, what if the owner doesn't know the identity of the
Oh, I agree with that.
nominated
The
party?
it's called the truthful alibi defense, where you might say, well, I was in Chicago, here's my hotel stubs, here's my itinerary, da-da-da. I don't know who drove the vehicle. But before the magistrate, you didn't make a record on that. And to claim that the statute is unconstitutional because it does not allow for a truthful alibi when you didn't make an offer of proof, does that allow you to raise the issue on appeal?
Well, I believe it does, Your Honor, because under the circumstances, first of all, the language of the ordinance, I don't think requires the city to find this nominated party to be the one liable. I mean, the language of the ordinance says the registered owner or nominated party, and the language of the ordinance still allows for finding the owner liable regardless of whether they've offered proof. of the
Mr.
nominated
Justice, I'm sorry.
Go ahead.
Justice Apple talks about nominated party. What is a nominated party? There's no definition here. I mean, are we supposed to speculate that a nominated party is a truthful alibi? Are we supposed to speculate that a nominated party is somebody who may have been driving? I know other ordinances define it. I've seen around the state, but to you as a person who receives a ticket, did you know what a nominated party was? How to present the defense? Did the code section, I mean, the ordinance tell you that stuff?
The ordinance didn't say anything about a nominated party as far as defining it, as far as describing how you go about to.
Oh, it says an affidavit of the ordinance says that you're to, admittedly uses the term nominated party, you're supposed to put in an affidavit who the nominated driver was actually. Is that hard to understand?
Well, I don't believe the ordinance said that you're supposed to prepare an affidavit for a nominated party. The ordinance just simply said that, from my recollection of the ordinance, it's simply that.
It's on the citation form, actually, the affidavit business. But
Right, so
why didn't you make a record before the magistrate? You go to the magistrate and say, hey, look, I don't know who drove the car. It's registered in my name, et cetera, et cetera. Who drove it? I don't know. But the city has failed to make its burden of proof. But that's not what happened. Instead, you kind of instead you said, well, the inference alone that I'm owner and was therefore driver is insufficient. And I'm not sure, I mean, I'm just asking, I'm just not sure that's enough.
Well, I believe that it is, Your Honor, because, once again, I don't think that number one, that there was sufficient notice of what a nominated party is or who a nominated party is and how one was supposed to try to offer evidence to prove that, first of all. And also, the fact that so therefore, I still believe that the ordinance only really allows for a rebuttable presumption if a stolen vehicle report was made.
Mr. Jacobsma, could I ask you a question? Are parking tickets unconstitutional?
Pardon?
Are parking tickets unconstitutional?
Well, I know this court did address that issue in the case of Iowa City versus Nolan. I believe it was back in 1976. And that case, this court held that parking tickets were not unconstitutional. But
so what's the difference?
Because in that case, in Iowa City versus Nolan, the statute at issue there, or the ordinance at issue there, still allowed for the owner to still come forth with evidence that they weren't the person that had the care, custody, and control of the vehicle that time. And I don't think the Sioux City ordinance does that at all. As a matter of fact, because the only very narrow exception that it allows for rebutting this presumption is if you file the stolen vehicle report, then really, I mean, even if I were able to come into court and prove that the vehicle was actually stolen, but if I didn't file the stolen vehicle report under the ordinance, they could still find.
It seems like the instruction page of the ordinance creates other exceptions. And my question to you is, can the instruction page trump the ordinance?
No, I don't believe so, Your Honor.
Well,
I mean, the ordinance is the law, not some kind of no letter or something you get from.
Oh, we
police
construe
department.
ordinances all the time to survive constitutional challenge. In the landlord-tenant case called Yeager v. City of Dubuque, the ordinance said that the housing commissioner could exercise certain emergency powers, and we said, well, that doesn't mean in his sole discretion, it had to be reasonably exercised and so forth. To the extent there's any ambiguity, shouldn't we be trying to save the ordinance from a constitutional attack through interpretation?
Well, even if the court chooses to do that, I think what the court needs to, at the very least, do is interpret the ordinance such that it requires that the ordinance be interpreted so that the presumption is rebuttable, completely rebuttable, not just in this narrow circumstance of if you file a stolen vehicle report. But under the court's
But my question is, can we use the ticket, the instruction page of the ticket, and say that was written in the ordinance, or are we bound by the terms that the city council used?
I believe that the court would be bound by the terms the city council used in the ordinance, because I don't think there's anything that requires the city council or the city of Sioux City to be bound by what they put in their ticket instruction.
I mean, what if they put in the instruction, if it happens on a Wednesday, you don't have to pay it? I mean, can they do that in light of the ordinance, or is the ordinance binding?
Well, I think it's the ordinance that's binding, not necessarily the instruction ticket.
What was your interpretation of 3B, which says that the vehicle owner or a nominated party shall be liable? What do you think that means?
I honestly didn't know what that meant, Your Honor.
Really?
I mean, because that's the only reference to nominated party that there is.
You didn't have any inclination that that might mean that you nominate a party of some kind?
Perhaps.
And if you could nominate a party, why didn't you make a factual record again?
Well, because, once again, I think the ordinance is unconstitutional on its face, because it, first of all, didn't mean, I don't believe it means that the city of Sioux City still has to abide by this nominated party. They can still find the registered owner liable.
Counsel, I'd like to broaden the conversation just a little bit. The city's brief points out, and as you well know, there are other instances in which our law makes the owner of a vehicle liable for activity that he or she isn't directly involved with. For example, the ownership consent statute 321-493. We also have the statute that has a provision: if you pass a school bus when the stop arm's out, the owner of the vehicle can be held, can be cited, even if the owner wasn't driving. Why is this statute different than those for purposes of the constitutional analysis?
Well, because I believe, Your Honor, what the city of Sioux City is really doing here, in those situations, it is more of a vicarious liability type of situation, where the owner is being held liable for the acts of the driver. But here I think the city of Sioux City is essentially making up their own vicarious liability scheme. In the case of, in the situation of the owner consent statute, where a person who consents to the operation of their vehicle, they get in an accident, they're negligent, and they cause damage to somebody, that is really more akin to the principal agent type of vicarious liability situations that the common law has always held to be the case. Here, the Sioux City ordinance doesn't require a proof or a showing that the owner gave consent to the driver in the situation. And even if it's proven that no consent was given, the owner is still liable. With respect to the other statute you mentioned regarding the school bus passing, I believe, if I'm not mistaken, that in that statute as well, the owner of the vehicle still has the ability to come forward with evidence that they were not, the vehicle wasn't in their care, custody, and control, and did not consent to the operation, which I believe would still absolve them. So that's why I think that the Sioux City ordinance is different, because it's creating this strict liability and vicarious liability scheme that really doesn't have to prove any relationship at all. You just are liable if you are the owner, and period. Except they give this one very narrow circumstance if you file the stolen vehicle report. Well, then you're not.
Counsel, could this ordinance be written to pass constitutional muster?
I don't believe so. I believe the ordinance needs to be stricken and
So
declared
this is not an area that a municipality or government can control in the manner that they're doing it?
Well, I also made a preemption argument as well, which I know this court has already addressed that in City of Davenport versus Seymour, and I am asking this court to re-examine that. But I do think that municipalities, when they venture into this area, it has to be consistent with the legislature's enactment of state law on this
Can't
issue.
they make this constitutional by explaining what nominated party does? Like I know the Cedar Rapids one does, the Des Moines one does, the Davenport one does. Explaining nominated party and giving you the right to refute the presumption, just like the implied consent statute. I mean, the owner-operator statute, if it has a right to, you know, it doesn't make it strict liability, or going through the bus stop, or where the stop site is in the bus. I mean, that would be constitutional. You don't see any problem with that, do you?
Well, may I?
But that's for another day.
May I respond, Your Honor?
Go ahead.
Because my time is up. Well, the only reason why I feel that's problematic is I don't think that would pass under this court's decision in Hensler versus City of Davenport, where the court said that even a irrational and arbitrary presumption that an event happens and a party is the cause of that is unconstitutional.
I'm sorry, but we've held in the parking ticket area, it's not irrational to assume that the owner was parking the car. Is it really that irrational to assume the owner was driving the car?
No, I don't think it's an irrational connection to try to make, but I do think that in order for the city of Sioux City to make the ordinance constitutional, to pass constitutional muster, they would have to amend it and rewrite it to, at the very least, I think, define what a nominated party is, that process, and what evidence that the owner can do to respond and provide proof to rebut that presumption.
Thank you, counsel.
Thank you.
Mr. Vondrak.
May it please the court, co-counsel, Mr. Jacobsma. We're here today to argue the legality of the Sioux City's photo enforcement program. Several years ago, the city began to use photo enforcement as a means to capture speeders as well as red light runners within the city. It has been alleged by Mr. Jacobsma that the city's ordinance violates his due process rights. I would argue that this is the very definition of due process. We're at the highest court. We can't go any further than this, and Mr. Jacobsma is allowed to make his argument in front of you, gentlemen.
Well, but what does it mean, this nominated party business? I mean, the point is that your opposition is making is that Section 3B says the vehicle owner or nominated party shall be liable, but it doesn't expressly state, at least, that you can nominate somebody. It doesn't expressly state that at a subsequent hearing evidence of who a nominated party might be admitted. He says he doesn't understand. He read the section. He says he doesn't understand what it meant. What does it mean?
Well, Your Honor, there are probably lots of different words in our ordinance that aren't specifically defined or called out, and at that point, I think we're obligated to go to the dictionary and figure out what nominated party is. Nominated in the dictionary can mean to name or designate, and the fact that...
Well, why couldn't he name you as the party? You were driving the vehicle. You know, if you read the Davenport ordinance, or you read the Cedar Rapids ordinance, or the Des Moines ordinance, it says you nominate the person who is driving the vehicle. Why couldn't I nominate you? And then you have to go in the court and say whether you have to pay it or not.
And Your Honor, Mr. Jacobsma fully could have done that, but he didn't do that. And in fact, he had three options when he got his infraction in the mail. Number one was to pay the ticket. Number two was to nominate a party. And number three was to ask for a hearing.
And
And what could he show at the hearing?
At the hearing with the police officer, Your Honor?
Well, let's start there, and then we'll go to the hearing before the magistrate.
Okay. At the police officer hearing, he would have had an opportunity to present his evidence to a police officer And at that level, the police officer would have the ability to dismiss it at that level. Should it go forward, then it would be sent to district associate court, like this one was, in front of a magistrate.
But where does the ordinance have that procedure in it?
Your
That
Honor-
you can present evidence,
Your Honor,
like the other city ordinances say.
I'll concede that in our ordinance, it doesn't discuss nominated party. But Mr. Jacobsma, in the alternative, was given the opportunity to nominate a party.
So the police officer could make up his own way or her own way how to nominate somebody because there's no procedure in there, or the back of the ticket can do it. Don't you think due process requires the city to give notice of what they have to do and what presumptions are there and what presumptions are rebuttable? I mean, isn't that what the essence of due process, to be given notice from the ordinance of what you do and what you don't do?
Well, I agree that the defendant needs to be given notice of what is going on, but I would add, he had that opportunity to nominate a party. If he read the ticket and found the second option would be to name a person and sign that as an affidavit to nominate the party.
So the ticket language could supersede the ordinance?
I don't believe the ticket language is superseding the ordinance. I believe that the ticket language actually in the alternative is complementing the ordinance, basically saying that this is what we mean by nominated party, and here's your opportunity to do so.
What would be so hard for the city to write the ordinance like every other one in the state and give them the notice? I mean, you're not like the only city in the state doing this.
And I would agree, but we believe that by saying that a nominated party can be charged with this offense, that, and in doing so in the citation, to give the defendant an opportunity to nominate a party, I believe we've satisfied the due process rights.
Well, you gave him actual notice, I suppose. I mean, it's the reverse side of the citation that has a business about affidavit, if I'm not mistaken. And that is not contained in the ordinance itself. Right.
That's correct.
But I guess we can assume, or can we, that a person getting a citation reads the instructions and therefore has notice that he can do an affidavit of some kind. But what is there in the ordinance that suggests that before the magistrate in particular, that he can offer evidence related to, I wasn't driving, I was in Chicago, somebody else was driving.
Well, unfortunately, our ordinance doesn't lay out all the defenses, much like a lot of the ordinances that we have lay out all of the defenses that the defendant is afforded or may present at the magistrate level.
If I received a ticket here, and I read the ordinance and it says nominated, and then I look at the back of the ticket and it says, well, I can do all this stuff, I mean, don't you think I have a problem? I mean, if I actually read the ordinance, so I do all this stuff, but I can't get out because the ordinance won't let me out. I mean, it's the ordinance that gives the due process, because even though you have this procedure, this doesn't say you're out if you do this, because the ordinance won't let you get out.
Well, I believe the ordinance does mention nominated party.
But it doesn't say a nominated party's out. You're out if you nominate somebody. The ordinance does not say that.
But the ordinance does say a registered owner or nominated party may be found liable. And with that, we expanded on the ticket and say, if you nominate this person, your ticket will be dismissed and a new ticket will be issued to this nominated party.
What do you do with the truthful alibi that you can't nominate a party, but I wasn't in town on that day? It was my car, and it was parked in front of my house and whatever, and I was in Cleveland. What happens on the ordinance then?
And I think that requires a long answer, and that meaning cities are granted home rule authority, and they have an obligation and an interest in protecting their citizens as well as their officers' property within the city. And if we have a vehicle, like you're saying, as such, that is violating the speed limits within the city or the red lights within the city, then we have an obligation to hold that owner accountable for his vehicle either speeding or running red lights. And additionally, the simple fact that somebody could be so loose with their vehicle that they wouldn't know who is driving, I think presents all kinds of problems. If I borrow Mr. Jacobsma's car and park in a handicap spot, come out of Walmart from buying a soda and chuck the ticket, Mr. Jacobsma is going to get a letter in the mail saying he owes $200, and I might be long gone. And in that example, he doesn't even have the ability to name somebody who was driving the vehicle. Additionally, in our jurisdiction, if you don't pay that handicap ticket, you don't even get to register your car. So the parallels here, I believe, are really similar.
But has that been held constitutional, where you cannot refute you were the person who committed the violation? Do you know any court that's held that constitutional?
I don't know of any that's handed.
So how can you compare a statute that may be unconstitutional to another statute that may be unconstitutional?
Your Honor, I guess I would argue that it hasn't been declared unconstitutional, and I believe it's a widely used practice.
Does that make it constitutional?
I'm not saying that.
You know, in the old days, they didn't let blacks go to school, go to white schools. That doesn't mean it's constitutional. It was a widely held practice.
Well, let me just ask this question. Is there a reason, we're studying the verbiage here. Is there a reason why the ordinance is constructed the way it is? Why isn't there more explanation of what a nominated party, is, or more explanation about the process? Why do you stick it in the backside of the citation? That seems like a little bit of a backwards way to do it. Why doesn't the ordinance, really spell it out? And the concern that, arises is that this is, kind of looks like a little trickery that, you have this vague ordinance and then you sneak on the backside of the citation that you might do an affidavit, and then you have a hearing of some kind, but you don't know what the rules are. And an average citizen might say, this is complicated, here's $75.
I can't answer why the nominated party wasn't there. I wasn't on the city council. I wasn't even advising the city council when the ordinance was drafted. But what I will say is, I do believe that by saying a registered owner or nominated party can be found liable meets the due process requirement. Had Mr. Jacobsma come to that initial police hearing and said, hey, I wasn't the driver, but John Adams was, at that point, I guarantee with 100% certainty that our officer says, oh, isn't it your lucky day? All you have to do is put John Adams' name right here. We'll send him the citation, and you're free to go. And so I don't believe, although the ordinance doesn't specifically lay out what a nominated party is, I believe it addresses it in the procedure. And the procedural due process, I believe, is spot on here.
Let me ask a question. Is a police officer, is the hearing officer, or the chief of police a neutral, the equivalent to a neutral magistrate hearing it? It's sort of like the person who gives the ticket gets to decide whether or not. Does that create some due process arguments?
Your Honor, at first glance it might. But what I will tell you is that of the 100% of tickets that go in front of one of our police officers, only 82% of those proceed. 18% get dumped at that point. And so I believe that's 3 or 4 times higher than what survives the magistrate level. So I do believe that it's a legit process. It's not a rubber stamp, and that the ones that go forward have an obligation to go forward. Like I said, I can't get away from the parking ticket example, but also the school bus example, the new law, 321, 372A, can hold a registered owner liable for actions of their vehicle if they're not able to point the finger at who the driver was. It requires the local jurisdiction to send a peace officer out and investigate what had happened. If that registered owner is unable to name a party, then at that point, a citation is issued to the driver. And that's a criminal citation. We're one step removed here.
But
This is a civil.
that's spelled out in the ordinance, though, in the statute, though.
Agreed. But I believe with the criminal aspect, we have a raised element of what we need to prove. This is civil. It's not reported to the insurance companies. It's not reported to the DOT. At that point, other than paying, to distinguish between this municipal infraction and that criminal penalty, that criminal citation, is a huge difference. And
Is it really a huge difference?
Your Honor, I believe it is.
I mean, whether you give a speeding ticket that violates a state statute or a speeding ticket that violates a civil ordinance, still $175 to the person who gets the ticket.
And I believe that's the key difference. It's actually $168 when an individual receives a citation. That is actually the same amount that our legislature handed down when they decided to make it the same as if a police officer were to issue the citation. Obviously, the reason that we're here today, other than maybe a vendetta against the whole program, Mr. Jacobsma, $168 was important to him. It's important to me, and I would assume that it's important to you. It's set that high so that driver behavior changes. Before the initiation of the speed program, we had 38% of drivers traveling in excess of 11 miles over the speed limit. Today, we're only capturing less than 0.75%. And the fact that these are working. I'd also add, obviously, that the legislature, since this court decided Seymour, has had 6 years to either enact legislation prohibiting automated traffic enforcement systems or to specifically allow them. We don't have anything yet. There's been numerous bills.
But Seymour
every
was
year.
a narrow issue, and I don't think, listening to your opponent's argument, he's really not asking us to overrule it. We're actually looking at a due process argument. We're not looking at the home rule aspect of the case. And even if the legislature didn't do anything, you could still have due process problems.
And I would agree with that, Your Honor. But what I am saying is that the legislature has failed to address this. And additionally, the Department of Transportation has promulgated rules even, whether we like those rules or not, the city complies by them and has promulgated rules basically governing such. The administrative branch has said, okay, we'll let the municipalities have these. But I agree, the due process arguments still exist.
Yeah, what if they passed a law, we could search your house without a warrant? I mean, they can't do it. I mean, they'd still have due process and Fourth Amendment and Sixth Amendment rights. So just because they didn't overrule the home rule aspect doesn't mean they've given their blessing to the due process argument.
And if I might respond, Your Honor, I'm running out of time, but I would agree with that we need to give our citizens all the due process that our Constitution requires. And I believe that Mr. Jacobsma has had that due process. He's had 4 hearings. This will be the 4th. The fact that he is here today, I think, is the example of due process.
Thank you, Counsel.
Thank you.
Mr. Jacobson, you may present your rebuttal argument.
Thank you, Your Honor. Mr. Vondrak stated that he didn't quite know, or the ordinance doesn't spell out all the defenses in this ordinance. Well, it looks to me like it only spells out one defense, which is you have to file a stolen vehicle report at the time that encompasses it.
Well, let me try this argument on you. I'm referring to a section of the code that relates to hearings before judges on municipal infractions. It basically says, this is 364.22, in a hearing before a judge on municipal infractions, the city has the burden of proof that the municipal infraction occurred and that the defendant committed the infraction. So under this code provision, the city has to prove that the defendant committed the infraction. And then we look back at the ordinance, and the ordinance, albeit kind of vague, does say the vehicle owner or the nominated party shall be liable. Well, reading those two together, doesn't it mean that the city has a burden of showing that you should be liable and that you have the ability to offer whatever evidence into the record you have to show that you shouldn't be liable?
Well, that would generally be the case, I agree, except that the ordinance, the language of the ordinance, I think is contrary to that. Because why, I don't understand how it would make any sense for the ordinance to specifically say that it can be rebutted by filing a stolen vehicle report, but not say anything else. And then argue that, but there's all kinds of other defenses which the owner can make, which is this or that, but we're not recognizing them.
It seems to me that argument shifts the burden to you to prove that you weren't the owner rather than the burden for the city to show you were the owner, because you don't have to say anything.
Of course, that happens in civil cases all the time. If a criminal case, you can't shift the burden, but in civil cases, there's lots of statutes that do.
One of the other arguments that Mr. Vondrak mentioned was, he made some mention of if a person's being so loose with their vehicle that they don't know who's driving it. I mean, and I think I pointed this out in my brief to you. I think there are lots of examples where things like that can happen. You know, if I let my son use the car and he turns around and gives one of his friends the keys to the car to go do something else, well, how am I supposed to know that he's driving?
Let me ask a question. I mean, let's just suppose hypothetically the ordinance imposed strict liability. Is it your view that strict liability on the owner of a vehicle is unconstitutional? And if so, what constitutional provision does that violate?
I think that it's unconstitutional if it's solely by virtue of your ownership.
And what provision does it violate?
It violates Article 1, Section 1 of the Iowa Constitution.
So it's your view that you cannot have strict liability because of Article 1, Section 1?
Correct, only unless you can prove causation.
But there was strict liability at common law in certain areas and doesn't Article 1, Section 1 only preserve rights as they existed at common law?
Yes, I would agree with that, Your Honor. And my argument is that at common law, even in strict liability cases, a person could not be held liable unless they also, it was proven that they caused.
I mean, for example, I think at common law, if you owned an animal and the animal caused harm, you could be strictly liable whether you were out of state at the time or not. Isn't that right?
But I don't know about that specific common law provision, Your Honor, but you know, obviously that, of course, presumes that you're in the care, custody, and control. But I don't think that.
But isn't an animal, you know, kind of, or at least a domestic animal, then is a pretty good equivalent to a vehicle now, right?
I would argue, I would agree with that. Yes, Your Honor, I would. But I think under our owner consent statute has kind of taken care of that to show that you have to at the very least consent to the operation of it. And I think the problem that the ordinance has here is it can prove, or it can find the owner liable even if the owner has never consented to the operation of that vehicle. I see I'm only a few seconds left, and unless the court has other questions, I'll be
Thank you,
finished.
Counsel.
Thanks.
The case is submitted, and we'll next hear the arguments in State of Iowa versus Donald King.